Asbestos is a collective term for a group of naturally occurring fibrous minerals that were widely used in construction and manufacturing due to their strength, heat resistance, and insulating properties. When asbestos-containing materials are disturbed, they can release microscopic fibres that may be inhaled. Prolonged or repeated exposure to these fibres can be associated with serious health conditions, including asbestosis, lung cancer, and mesothelioma. Because of these health risks, the use, handling, and removal of asbestos has regulated globally or banned in many jurisdictions, and asbestos exposure is a frequent subject of occupational safety laws and litigation. Employers' liability and law. Employers have clear health and safety obligations to workers under the law in Ireland. Negligence occurs where one person owes a duty of care to another. Examples are one road user to another, a doctor to a patient, an employer to an employee. There must be a breach of this duty. The exact breach must have caused the damage. The harm must be foreseeable. In one case, it was stated, when the danger is reasonably foreseeable, the duty to take care to avoid injury to those who are proximate, when their proximity is known, is based upon the duty that one man has to those in proximity to him to take reasonable care that they are not injured by his acts. In addition to a duty of care, employers have duties under the Safety, Health and Welfare at Work Act 2005 regarding workplace safety. Case process. If you have been exposed to dust containing asbestos and asbestos fibres, and as a result contracted asbestos-related diseases at work, you may be eligible to make an asbestos injury claim. If you attend with a solicitor, they will furnish an opinion to you in terms of negligence. It may be that family members are attending with a solicitor if a tragedy has occurred. To succeed in an asbestos work injury claim, it must be proved that the exposure was due to negligence of the employer in an employer liability case. A commenced case proceeds to the Injuries Board. Form A is the application form to the Injuries Board. Form B is the Injuries Board's form for the doctor who is completing the report. If the case is not dealt with or concluded in the Injuries Board process, then legal proceedings, mediation, or early resolution can be explored. At the outcome of the Injuries Board process, once a decision is made, the applicant and respondent must agree to the assessment. In that case, the matter is concluded. If either side do not agree to the outcome, the Injuries Board consider the matter too complex, or for another reason, can issue document titled authorization. In this circumstance, the application must proceed to court if they want to advance their case. Damages can include medical expenses, loss of earnings present and possibly future, damages for belongings, and for pain and suffering. The judicial guidelines established under Section 18 of the 2019 Act, which catalogue the level of damages for this type of matter which can be awarded. We assist clients with cases from the start to finish, preparing and submitting the PIAB application, gathering evidence and expert reports, representing our client in court, if necessary, and dealing with any negotiations. If you have any questions, our contact details are 01 546 1121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.